Yes, I seek your lordship's indulgence in mentioning part 2, item number 7. Even though, my lord, this is a fixed item, if this matter may kindly be taken up after the ensuing vacation, my lord. After the ensuing vacation.
I thought you said after the admission matters.
No, my lord. No, my lord.
Which item then?
Item number 7, part 2.
725 matter. Okay. Prayer of learned amicus. List the matter after the vacations.
I'm obliged.
Daily list for admission, item numbers 1 and 2.
Your Lordship, I am appearing on behalf of the state respondents. If I may be given another a week's time to file my additional affidavit.
I'm
Yes.
sorry, my lord. I'm appearing on
Okay.
behalf
Catch your breath. Yeah, catch your breath.
I'm so sorry, my lord. I was in the TV. I have a request to pray to fix this matter, item number 1 and 2, my lord, on if possible on
Today's list.
Yes, my lord, daily, on the 7th of August.
7th of August.
Yes, my lord.
This is about some land matter. Land is to be acquired.
My lord, my apology, I'm not acquainted with the facts of the case. I have just received the information, the request from Mr. P.D. Nair.
So some rifles is to pay some money to the
Yes.
government for the preliminary survey.
Yes, Your Lordship.
Anybody appearing for some rifles? Who is online? Not this item.
Your Lordship, I appear on behalf of CGC.
Okay. So have you filed any affidavit?
Yes, Your Lordship.
You have?
Yes, Your Lordship.
Okay, I had learned counsel for the petitioner. Learned additional AG Mizoram praise for. Shall you record additional AG?
Lordship, I am appearing on behalf of the additional AG.
Prayer is made on behalf of learned additional AG for further time to file an affidavit. Prayer is allowed to list the matter on 7th of August.
Okay.
Item 3.
Yes, may it please your Lordship. My Lord, respondent number 1 is represented today, and I have taken steps for service of notice upon respondent number 2, and I have filed talabana. However, it appears that service report has not been returned till date.
Learned counsel for the petitioner, Mr. Suhensu, appears for respondent number
1.
Okay. As per office note, service on respondent number 2 is not yet complete. Await service. List again after 2 weeks. Give it.
29.6. Item 4.
Your Lordship, this is regarding a challenge to the airship issued by the Lord of Lords.
And my Lord, I am the respondent in this case, and I have already filed my objection as well. So this matter is ready for hearing. However, my Lord, the conducting counsel, my senior, he is on his legs in courtroom number 1. So if the matter may be passed over for a short while.
It has come in the admissions column only.
Yes.
So if we have to hear it, we have to admit it and list it for hearing.
My Lord, that can be done.
Had learned counsel for the petitioner. It is submitted on behalf of the respondent that affidavit has already been filed and the matter is ready. for hearing, hence admit the appeal. TCR?
Yes.
TCR?
Already received.
Yes,
my lord.
already.
Huh?
Yes.
Received?
Yes,
Yes,
received, already
received, my
received, my lord.
TCR has already been received, hence list the matter for hearing. After 4 weeks?
Obliged, Your Lordship.
16-7. Item 5.
May it please your lordship, my lord, Mr. P.D. Nair, the counsel for the petitioners has requested me to pray this honorable court to fix this matter on the 7th of August. He's the same counsel as the item number 1 and 2. He's an outstation counsel.
All right, prayer is made on behalf of Mr. P.D. Nair,
Yes, my lord.
learned counsel, for adjournment. Affidavit in opposition has already been filed.
Lordship, we have already filed. Pleadings are completed.
And readings are complete. So can it come up from the hearing column then?
Yes, Your Lordship.
Matter is admitted for hearing. List the matter for hearing on 7th.
Yes, my lord, 7th of August.
Item 6.
My lord, the respondents are yet to file their affidavit.
Your Lordship, I have received a copy of the parol's comments. However, some of the annexures are not legible. So if I may be given another 2 weeks' time to file my affidavit.
Same story, last 3 occasions. And I have seen only 3, not prior to that. Rules 2 and 3. You are for whom?
The state respondent. Lordship, I am appearing on behalf of all the respondents.
Heard learned counsel for the petitioner. It is submitted on behalf of respondent, on behalf of the respondents, that parawise comments have been received, but some of the annexures are not legible, and accordingly further 2 weeks' time is sought to file affidavit. Para it appears from order dated 14/11/25 that separate affidavits have to be filed on behalf of respondents number 2 and 3. Full stop. Respondents to file their affidavits positively before the next date fixed with advance copy to the petitioner. List again on
25-6.
Obliged.
Item 7.
Lordship, learned counsel for the petitioner is on leg for DB. May the matter be passed over for the time being.
Let's see what the matter is first. You are for?
Respondents number 1 to 3.
So affidavits have been filed?
Not yet, Lordship. Lordship, I will not be filing affidavit in opposition.
Okay. Okay, follow up after some time.
Item 8.
Your Lordship, on behalf of my senior, for filing respondent 1 to 3, I will filing Vakalanama within 2 weeks.
What's taking you so long to file the power? Granted time on the earlier occasion also. Are the respondents stationed elsewhere?
Yeah, yes, sir. Yes, Your Lordship. There are some defects in the Vakalama they sent. We need to make some correction.
None appears for the petitioner. Learned counsel who enters appearance for respondents number 1 and 1 to 3. Raise for how much time? 1 week. How
For
much
2
time?
weeks. For 2 weeks. Within 2 weeks.
2 weeks. Time to file Wakalatnama. As the respondents are stationed in New Delhi. Also, allowed raise the matter again after 2 weeks.
29-6. Item 9.
May I please, Your Lordship?
Yes.
Lordship, as per the last order, steps has been taken upon respondent number 3 to 7.
My lord, I have submitted my power for the private respondents. All right, all the private respondents, and I have received copy of the petition. However, my lord, if I may indulge your lordships for just 1 minute,
Yes.
I would like to give your lordships the record, the petition that has been issued to me, that has been furnished to me by the petitioners. My lord, the annexures, these are not legible. These are illegible.
What is that?
This
Report.
is the annexures attached along with the petition. And also,
Lordship, I will furnish
and also
that.
page number 20, some page numbers are missing.
All right, heard learned counsel for the petitioner, Miss so and so appears for respondents number 1 and 2.
Yes, sir.
Mr. so and so appears has entered appearance for the remaining respondents. The file power.
I have already filed my power. I have filed yesterday, madam.
Learned counsel for the said respondent submits that although copy has been furnished, some of the annexures are not legible. Learned counsel for the petitioner undertakes to submit legible copies thereof before the next date fixed. Hence, release the matter again after 2 weeks.
And Lordship, if possible, on 17th of July, if possible, Lordship.
Okay?
Lordship, interim order is there, that may be continued.
There is no necessity of continuing. It says shall remain state until further orders. So until we vary it, it will remain in force.
Much obliged.
It's not till the next date of listing.
Item 10.
Lordship, in this matter also steps has been taken on the private respondents.
Appearing.
My lord, we will be appearing for the respondent number 3 to 9 and we will be filing our power within 1 week.
Okay, heard learned counsel for the petitioner and so for the state respondents. Ms. So-and-so enters appearance for the respondents number 3 to 9 and submits that power will be filed within the week.
1 week, my lord.
Within 1 week, hence list the matter again. Next Thursday.
Same date may be given.
Same date.
Same date, 17th of July.
17-7.
Okay.
Item 11.
This also.
Yes, yes, same.
Okay, same order. Respondent numbers are same? 9?
Respondent numbers 3 to 10.
3 to 10. Same date?
Item 12.
My lord, I have submitted power in respect of all the private respondents.
So all these are same matters.
Same matters, my lord. Item number 12 and 13
Yes.
also.
12 are your 4 respondents.
Private
13.
respondents, my lord. All the private
Number?
number 3 to 11.
Okay, 3 to 11 in item number 12. Okay, rest are same.
Item 13.
And in item number 13, my lord, I'm appearing for the private respondents 3, 4, and 5. 3, 4, and 5.
3, 4, 5. Okay. Same.
Item
Much
14.
obliged.
My lord, I am appearing on behalf of the petitioners, and if I may be allowed to file the affidavit in reply to the affidavit in opposition of the state respondents, my lord.
All right, heard learned counsel for the petitioner and learned counsel for the. You are for?
Lordship, I'm appearing on behalf of respondent number 1, 5, and 6.
Counsel for 1, 5, and 6.
May I seek another 2 weeks' time for filing affidavit in opposition?
Who seeks 2 weeks' time to file affidavit in opposition? You are for?
State is 2, 3, and 4, my lord.
Mr. So-and-so appears for the state respondents, that is respondents number
2, 3, and 4.
2, 3, and 4. And affidavit on behalf of the said respondents have already been
Yes.
filed. Learned counsel for the petitioner 6. Time to file affidavit in reply. Prayers are allowed. List the matter again on
2-7.
Obliged, my lord.
For orders, item 15.
May it please your lordship.
Yes.
My lord, my senior has personal difficulty today, so if this matter may kindly be taken up after 2 weeks with the consent of the other party.
Yes, petitioner.
Yes, your lordship, they have taken our consent. Your lordship, kindly a date may be fixed, your lordship.
All right, on the prayer of learned counsel for the respondents and with the consent of the petitioner side, list the matter again on. Yes,
24th.
Huh?
24th of July, your lordship.
Or 24th of July.
Your lordship, there is a status quo order, if that can be continued, your lordship.
What status quo order dated?
Order dated 29/4. There was, but on 21st of May, your lordship, I was not able to present. My junior had appeared, so it was not continued on that day. 29/4. Till 29/4, there is a status quo.
All right, status quo order passed earlier shall continue till the next date of listing.
Deeply obliged, Your Lordship.
Item 16.
My lord, I'm appearing on behalf of the Legal Aid Counsel, Mr. Sitlan Tianglima. And if this matter may be listed on 23rd of June for admission hearing.
When?
23rd of June.
Otherwise, what is the stage? Any objection has been submitted? No.
No, my lord.
We'd heard learned counsel for the appellant. Learned legal aid counsel appearing for the sole respondent. Praise for adjournment. For what? Filing objection?
My lord, for admission hearing.
No, you want to file some objection?
No, my lord, we won't be filing.
Praise for adjournment. List the matter for admission again on.
23-6. Item 17.
I'm appearing on behalf of my senior who is on late lordship. And as per his instruction, my lord, we have submitted additional affidavit on 9/6/2026.
If I may, my lord, as per the last order, they were to explain the time period spanning from 8/8/2024 and 16/4/2024. 2 time periods, my lord. So they were to explain the time period for the reasons for the delay, spanning from the time period of 8/8/2024.
Okay, so that affidavit has been filed. Would you like to file any objection to that?
Yes, my lord, I will file my
All
objection.
right, heard learned counsel for the petitioner and learned counsel for respondent. Additional affidavit has already been submitted, which has been placed on record. Learned counsel for the respondent seeks time to file objection to the said additional affidavit. Hence, list the matter again on.
2-7.
Obliged.
I will pledge.
Item 7 for admission.
Seven. But not yet.
Not yet.
Still on legs.
Not legs in the other court, my lord. Counsel for the petitioners.
Any what item is left? There is one matter, I think, hearing matter in the. We can begin that.
Item 18 for hearing.
Yes.
May I please, Lordship? My lord, this is the night appeal, and with regard to the
representation of the claimant before the trial court. In this present appeal, the claimant was not represented, my lord. The claimant is the respondent number one herein, my lord. Despite an attempt to duly serve the summons and notice. So that was not accomplished, my lord. That we
He is not served.
not served, my lord.
Then how is it come to hearing?
Yes.
No paper publication also.
Paper publication was not done, my lord. In this regard, my lord, we are also contacting the learned counsel representing the claimant before the tribunal also. But she had also informed that she is unable to contact them also, to contact the claimant. She is unable to know the whereabouts of the present exact location.
That is respondent number one.
Yes, my lord. Respondent number herein in the present appeal.
The paper publication has been made. Order dated 29/10/24, long back.
Yes, my lord. That is long back.
So that is why it was fixed for hearing.
Yes, my lord. It was fixed for hearing. In absence of the respondent number one, who is the claimant before the tribunal.
So it is you who should apprise the court.
Yes.
You are saying submitting otherwise that it has not been published.
So far as my knowledge,
You are senior counsel. You have a responsibility now. Greater responsibility.
yes, I thought that, my lord, yeah, it was not published, but it was published a long time back, my lord.
So service was deemed to be complete.
Yes, my
Notices
lord.
are,
Exactly.
in view of the aforesaid publication of the notices through alternative mode, the notices are held to be duly served on respondent number one. Hence, list the case for hearing.
Yes.
Then,
Correct, my lord. Then, my lord, hearing may be done in absence of the respondent number one also. my lord.
yes, he has been served.
Yes.
If he is not present, what is there to do?
Correct, my lord.
At best. But that is also, this is a private dispute. You are for the insurance company. You are for whom?
My lord, I am for the rest
Appeal has been preferred by whom?
by the owner of the vehicle. I had purchased the vehicle from the respondent number two. So responsibilities lies upon and direction was made for payment of the compensated amount to the claimant, my lord. And in that regard, the ownership of the vehicle the registration was still not changed, transferred in my favor. But anyhow, I accepted that the sale deed had already completed at the time of occurrence of the accident, my lord. Here, my lord, with regard to this present appeal, I made some grounds, but I would like to make my submission particularly with regard to the monthly income of the deceased, my lord. I would like to not press upon the other grounds, only more particularly with regard to the monthly income of the deceased. Here, my lord, by passing the impugn judgment order,
Vehicle was not insured.
vehicle that was invalidly insured. The insurance was not valid at the time of occurrence of accident, my lord. So liability falls upon me. So the final amount of compensation which was directed to be paid by me was at the tune of rupees 39 lakhs 25,800, my lord, by calculating the monthly income of the deceased as rupees 29,000.
You are the old owner or the new owner?
I am the new owner, my lord. I am
New
the new
owner.
owner. Yes, I had purchased that vehicle from the earlier owner. Still ownership was still not transferred.
Registration was not made on the date of accident. Registration of the vehicle was still with the old owner.
Yes, exactly, my lord. Exactly.
So you admitted having purchased and used it. So
I had admitted ownership, and my submission will be more particularly with regard to, my lord, the income of the deceased, which was taken as the computation basis by the tribunal.
so you are on the quantum.
Yes, I'd like to press with regard to the quantum only.
Okay, what is the calculation? Where is the
The calculation is at page 25 of the impugn order, which is placed just before the appeal petition, my lord, the page 25.
so the income of the deceased is stated to be 29,000
29,000, yes, my lord. Here,
and the blacksmith.
yes, written as blacksmith. And my lord, here, if your lordship may kindly see the evidence of the claimant. The evidence of the claimant, which is at page 10 of the impugn order, impugn judgment order, my lord. This income certificate was issued by the village council president.
What is the documentary evidence? Any documentary evidence regarding income?
The income with regard to the documentary evidence, my lord, here
Because everything will be based on the income.
Yes, the income certificate was issued by the village council president, my lord. But
Showing how much? 29.
showing the amount as rupees 29,000. by mentioning his profession as a blacksmith.
What is the name of the deceased?
The name of the deceased.
Lalthanga.
Yes, my lord. Elthanga. Elthanga, 30 years, a resident of Dintar Aizawl.
Dintar. Okay. That's who is in Aizawl city?
Yes, within Aizawl city. Western side of Aizawl city. And my lord, with regard to that, if I may read the impine order, my lord.
Yes.
Which is at page 9 from para 8, if I may read, my lord.
Page 9?
Page 8, from page 8, the para
8 of the judgment.
Page 9 of the judgment, yes, page 9 of the judgment.
Yes.
From para 8, my lord. Para 8. Claimants, if I may, my lord. Claimants number 8, Arthang Lura, son of Saitang Puyadin Terveng, Aizawl stated that he was elected as chairman, local council Dintar between the period of 2012 to 2015. He knew the deceased Elthanga, who was residing at Dintar in a rented house. The deceased Elthanga was the only blacksmith in the locality. He knew for a fact that the deceased was living in a rented house and was also running a blacksmith workshop in a rented house in their locality. He knew the nature of the works performed by the deceased and the income earned by the deceased could not be less than 29,000 per month. This amount is arrived knowing the nature of work of the deceased. He also knew for a fact that the deceased was renting the house of Pirongeti on a monthly rent of rupees 4,500, which was confirmed by the owner of the house, and the workshop was rented for rupees 1,500 per month. He identified exhibit so-and-so, certificate issued by him, and exhibit so-and-so, his signature. He also knew that the deceased was only bread earner of the family. In his cross-examination by the OP number 2, he admitted the suggestions that he did not see the deceased receiving rupees 29,000 with his own eyes, nor did he see any documentary evidence, such as cash book, etc., and that he did not see the deceased paying his rent of his rented house and workshop. He came to know the amount from the owner of the building. He also stated that the income certificate issued at exhibit so-and-so is based on the sitting of a local council and based on the nature of the work of deceased. So, my lord, here the village council president had issued the income certificate, wherein he did not see deceased exactly receiving monthly income with his own eyes, nor did he see any documentary evidence such as cash book or etc., and that he did not see the deceased paying rent. So he did not know anything about this, the exact particulars of his monthly expense as well as income of the deceased. Simply, he stated that it could not be less than 29,000 on monthly basis. So here the decision was made by the tribunal by relying on the income certificate issued by the village council. So my lord, here.
So according to you, what should have been the income?
According to me, my lord, here the income of the deceased has to be based on the notification made by the government of Mizoram with regard to this
skilled workers.
Yes, Mara, skilled worker.
What's the rate?
The rate according to us will be rupees 570 per day.
So around 20,000.
On monthly basis, it will come around 3,420 if he works weekly.
3,000?
3,000
If it's 500 daily, 500 what?
570. If you work 6 days.
570.
70.
Okay.
And if he works 6 days in a week, then on monthly it will, that is weekly, 3,460 will be weekly. And on monthly basis, it will come around 13,680. So
Rest of the calculation is okay.
Rest of the
Based on that
rest of
figure?
the calculation, I have no issue, my lord. I would like to press upon the amount, the quantum of the monthly income only, my lord.
You have annexed the notification.
Yes, no, I have the copy here, my lord. If I,
What is the income stated in the claim petition?
the income state in the claim petition is rupees 29,000 on monthly basis.
Where is the rate mentioned?
My lord, in that notification, the rate is mentioned that the notification dated 16 June 2023. At the first row, casual master role employees. The category of workers is categorized as unskilled, semi-skilled, skilled 2, and skilled 1. And the blacksmith,
This notification is dated 20 January 23. You're referring to something else.
20 January, that is the category of blacksmith categorized as skilled labor.
Okay,
my
this
lord.
is okay. 16 June
There is
23.
another notification, my lord. The blacksmith is categorized as skilled labor. And here in that another notification, 16 June 2023, my lord, here the blacksmith, which is categorized as skilled labor, is written as rupees 570.
This notification mentions 4 categories: casual or master role employees. That means working in a department.
Yes, this is generally for those workers who are working in the department. But
So this is just a guide.
yes, it is somewhat like a guide. Yes, my lord. This
So, okay, let's then come to rates are same in every category.
yes, my lord.
So there are 2 categories of skilled 1 and skilled 2, right?
Yes, correct, my lord.
One is 570 and one is 730.
Yes.
So
In that skill 1 category, my lord, the explanation is made. In that skill 1 means experience in the work requiring great skills. In that notification 16 June 2023. At page 2, the skilled 1 is the senior grade. It means experience in the work requiring great skills.
blacksmith doesn't require great skills.
According to me, my lord, here it will fall under the skill 2, means work which involves skills or competence acquired through experience on jobs or through training as apprentice in a technical or vocational institute, and the performance of which calls for initiative and judgment. It also requires skills, but if the category to be fall under the skilled 1, it requires great skills, my lord.
So it would mean grade 1 would mean senior grade would mean something of a specialized category. Some specialized
Yes, exactly.
work.
Exactly, madam. Yes, correct.
Which not everybody can do.
Yes, correct, madam.
The definition could have been more precise. No, great.
Exactly.
Vague term. Great skills. It's capable of
Great skills
lot of
needs to be more.
interpretation.
Yes. It needs to be explained in a more specific manner.
You are for whom?
The registered owner, respondent number 2.
Okay, so you have no say, really.
Yes.
My lord, here, if I may, my prayer is with regard to that monthly income only, my lord. Here, if it was
After that
calculated,
calculation will follow as
yes,
as
other
per the one
calculation will
given in
follow,
the
my lord.
judgment.
Yes, correct, madam.
All right, take down. Heard Mr. French, learned counsel for the appellant. And Mr. So-and-so appearing for the respondent number
2.
None appears for the respondent number 1 stroke claimant. It appears from the records as reflected in the order dated 29/10/24. That this court-wide order dated, that is third para of order dated 29/10/24, okay. Para, in view of the same, notices were held to be duly served upon the respondent number 1. However, none had appeared for the said respondent. Para, the present appeal has been preferred by the appellant, who was arrayed as a in the claim before the tribunal, you were number, you were
Opposite party told you.
Respondent number 2.
2
Two.
in the tribunal,
Yes, Madam.
was arrayed as respondent number 2 in the case before the Line Motor Accidents Claims Tribunal, Aizawl, challenging the judgment and award dated so and so, whereby the liability for payment was cast upon the present appellant. Full stop. The facts of the case may be briefly stated. Paragraph 1 of the judgment. So insurance company was never a party, no?
Yes, never a party, Madam.
Para, since the vehicle was uninsured, no insurance company was made a party to the proceedings. The OP number 1 had submitted a written statement stating that she had already sold the vehicle to the present appellant by executing sale letter between seller and buyer on 17/4/2014 in the presence of witnesses, and hence the liability is upon the new owner, within bracket buyer of the said vehicle. Para, OP number 2, the present appellant also contested by filing written statement wherein she took the stand that the OP number 1 being still the registered owner was liable for any compensation that may have to be paid to the claimant. the question that arose for consideration before the learned tribunal, comma, with which we are concerned in the present appeal is with regard to the party upon which the liability for compensation is to be fixed. Full stop. It may be stated that on all other issues regarding, including regarding rash and negligent driving, the findings were in favor of the claimant, comma, which are not under challenge in the present appeal and therefore need not detain this court. Full stop. Para. Learned Mr. Swenson, learned senior counsel for the appellant, submits that the only ground on which the appellant proposes to press this appeal is regarding the quantum of compensation. Full stop. It is submitted that the learned trial court erred in proceeding on a finding that the monthly income of the deceased was rupees 29,000 per month, which was based on a certificate issued by the president of the village council.
Yes, my lord.
Chairman.
President.
A chairman. No, it's
Sorry,
in the
it's
CW3 chairman local council.
Yes, correct, my lord.
Chairman of the local council. And there is no other direct evidence, either documentary or oral, regarding the income of the deceased, and therefore his income has to be taken as the rates of income, rates of wages for skilled workers as per relevant government notification. In this regard, learned council has placed on record 2 notifications issued by the government of Mizoram. The first of the said notification is one dated notification number so and so, dated 20th January 2023. No, it is 19th. Okay, 19th January 2020. Published in the Mizoram Gazette Extraordinary on 20/01/2023. Notifying the Mizoram Code on Wages Rules 2022. Wherein within quotation, blacksmith and blacksmith within bracket class 2 have been brought within the category of skilled workers. Full stop. The second notification is the notification dated 16/6/2023. Notification number so and so dated 16/3/2023. I have highlighted the number. Whereby the government revised the minimum rates of wages for workers employed in the scheduled employment of various daily waged employees under the government departments, semi-government organization, public undertakings, private undertakings, and on contract basis, as shown in the table provided in the said notification, with effect from 1/4/2023. The said table of wages may be reproduced below for the sake of convenience. Okay, there is a table giving the rates, you copy that. Para. Reverting to the evidence on record, it appears that the chairman of the concerned village council was examined as CW number 3. He deposed that he was the chairman of the local council Dintar between the period 2012 to 2015, and he knew the deceased, who was residing at a rented house in Dintar, paying a monthly rent of rupees 4,500 plus rupees 1,500 per month for the workshop. Full stop. He further deposed that the deceased was the only blacksmith of the locality and being acquainted with the nature of the works performed by the deceased, and he opined that the income of the deceased could not be less than rupees 29,000 per month. During cross-examination, he admitted by the OP number 2, that is the present appellant, he admitted the suggestions that he did not see the deceased receiving rupees 29,000 with his own eyes, nor did he see any documentary evidence such as cash book, etc. And he also did not see the deceased paying the rent of his rented house and workshop. Full stop. He came to know the amount from the owner of the building. He also stated that the Exhibit C17 income certificate showing an income of rupees 29,000 per month is based on the sitting of the local council and based on the nature of the work of the deceased. Full stop. Para. A perusal of the aforesaid evidence would show that the documentary evidence, that is the purported certificate of income issued by the chairman of the local council, is not based on any other documentary evidence or record of income of the deceased, but is based on assumptions. Full stop. It is difficult to see how the chairman of the village council, without being closely associated with the works of the deceased, could depose to the actual income of the deceased. Or the income. What did I say? Just read the last one. Depose. Okay. Up to the and could issue a certificate in this regard, stating a precise figure. Full stop. Para, having regard to the nature of the evidence available on record, this court is inclined to accept the submissions of learned counsel for the appellant, that the income of the deceased has not been proved on the basis of legally acceptable material. Full stop. Before that para, you add one para. Although the CW1 had stated that he had come to know from the owner of the building about the quantum of rent that was being paid by the deceased, the said owner was never examined during the trial. And therefore the evidence of the CW3 in this regard is purely hearsay. Para, As per the aforesaid notification dated 16/6/2023, skilled dash Roman 2 within bracket junior grade means work which involves skills or competence acquired through experience on jobs or through training as apprentice in a technical or vocational institute, and the performance of which calls for initiative and judgment. Whereas skilled dash 1, give this in capital letters, okay? Skilled dash Roman 1 within bracket senior grade, all capital, means experience in the work requiring great skills. Full stop. It is para. It is the considered opinion of this court that the blacksmith would come within the category of skilled 2 junior grade, as the work of a blacksmith certainly involves skills and competence acquired through experience or training, and its performance also calls for initiative and judgment. Whereas, not whereas, full stop. On the other hand, in order to qualify under the category of skilled dash 1 senior grade, comma, the same pertains to work requiring great skills, which should ordinarily indicate a very specialized line of work. Full stop. In the submission of learned counsel for the appellant is on the above line, and in the absence of any counter submissions in this regard, comma, the court finds no difficulty in accepting the said submissions to hold that the wages prescribed for skilled dash 2 junior grade that is rupees 570 per day should be taken into consideration while computing the monthly income of the deceased, who was a blacksmith by profession. Full stop. Taking the working days in a month to be it will not be 24, but one day more, because there are 30 days in a month. So,
My lord, usually
if we take it weekly, then
it's usually here in our Aizawl area, my lord, here
huh?
within Mizoram, my lord, within the context of Mizoram. Usually Sunday is a holiday. So only 6 days is for.
Yes, 6 days, but in a month there are 30 days. So 4 weeks is 28 days. Or we can do one thing, we can take 6 days and multiply with 52. 52 weeks in a year.
Yes, my lord. Then may be appropriate.
But just a moment, we have to take the monthly. All right, let's do it like this. Where did I stop? 6 days a week. The weekly income would be rupees 570 into 6 equal to
3420.
34230. And therefore the annual income can be computed by multiplying the weekly income with the number of weeks in a year, that is 52. Hence the annual income is computed as that 34 whatever into 52 equal to whatever. Okay, find that. Where a learned counsel for the appellant submits that as far as the rest of the computation is concerned, as reflected in the impugned judgment and award, there is no difficulty or objection to accepting the manner of calculation based on the, which however has to be based on the annual income, which is to be taken as rupees whatever figure you find. Okay, after multiplying with 52. Accordingly, the compensation is recalculated as follows. We go to page 25 of the judgment, paragraph 19. Okay, I have to recalculate. Accordingly, the appeal is allowed by altering the amount of compensation as calculated above. Full stop. The rest of the findings will remain the same as recorded by the learned tribunal. Appeal stands disposed of accordingly. Sent back down, which is photocopy, I think. Okay. The notifications referred to above be kept on record.
Ably obliged, my lord.
Item 7 for admission.
Yes.
Yes. My lord, this matter is a cover matter, which is covered by the order judgment of this coordinate bench of this court in WPC 79 of 2020.
Where is that order?
In page number 49. The operative portion is on, starts from page number 56, para 17. My Lord, may I kindly bring you to page number 43, which is the so-cause notice given to the village council president. Then its English translation is on page number 44 at Annexure 9A. Here only the village council president is given so-cause notice, but the other members of the village council were not given so-cause notice in this case. In
This is the impugned order.
yes, the impugned.
So you are
so-cause
only
notice.
asked to submit a reply. Is it not?
He is not intending to file counter affidavit.
Eh?
Yes.
No, you said it's a covered matter,
Yes.
meaning thereby that it can be disposed of. Is
Yes,
that
my
your
lord.
submission?
Yes, my lord.
Now you are saying he has not filed reply. What is it that do you want?
Yes, Lordship, I will not be having any objection regarding the matter.
If it is disposed of in terms of this order.
Yes, Lordship.
What did the order say?
In page number 56 on para 17. May I kindly read out, my lord?
No. But this is an order, impugned order was an order of suspending the village council.
Yes, it is suspending the village council.
But your, this English annexure that you have shown me, that doesn't talk of suspension, it's only calling for a reply.
Yes, the notification for suspension is on page number 47, and its English translation is at page number 48. But why I have shown you the so-cause notice is that only the village council president is given a so-cause notice for the suspension of this village council. The judgment which I have annexed at page number 49, which was passed in WPC 79 of 2020, stated in para 17, page number 56, that may I kindly read out, my lord? Para 17 of the judgment at page number 56.
This is also in the Lai Autonomous District Council.
Yes, Lai Autonomous District Council.
But in your case, was there any one-man committee? Where is the order of this appointment of inquiry commission? Anything is there?
That is not given.
The case which you are referring to, that judgment and order, it relates to the appointment of the one-man commission.
Yes.
The court held that it was not as per rules, the appointment of the one-man commission. But in your case, is it a case that a one-man commission was appointed and according to its recommendations, action was taken?
Yes, my lord. On page number 48 of the impugned notification by which the village council was suspended, it is simply stated that by this notification number such and such 6/11 November 2025, so-called notice was given to Saibo 1 Village Council on a complaint received by Mr.
It says an inquiry commission was formed with effect from 6 November 25.
Yes.
But we don't know whether it was formed as per the rules or not. In the case you have
but that case
submitted that it was held that it was not held formed as per rule. So how do we say that this is covered unless you can show us how it was appointed?
On page
First you have to satisfy that the case is similar to the one you are relying on.
On page 70, para 17 of the judgment which I have annexed at page number 56. On perusing the materials available on record, it is seen that so-called notice had been issued only to the village council president of various village councils, and reply had been sought for only from the village council president. That out of 23 writ petitioners in all the 5 writ petitions, it is an admitted fact that 4 writ petitioners had been issued notices, though the government advocates had submitted that 5 writ petitioners had been issued notices. The same is denied by the council for the petitioner in WPC number 66/2020. Thus, even if there is a dispute as to whether 4 or 5 writ petitioners had given so-called notices by the LADC, it is an admitted fact that all the 23 petitioners were not given notices. The village council member, including the village council presidents, have all been elected to their office, though adult suffrages. The village council president is appointed only from amongst the elected village council members. As they are all elected members, each member of the village council has a role to play in the administration of village and handling of funds. If the rights of the entire village council is to be affected to their detriment, it is a requirement of the principle of natural justice that each and every member of village council is given a chance to be heard. Otherwise, it amounts to condemning the other village council members who have not been given any so-called notices prior to suspension of village council. As such, this court finds that non-issuance of any notice to the other petitioner village council members who are not village council presidents violates the principle of natural justice, and the same has caused prejudice to the other village council members. My lord, in the instant case, there are 3 elected village council members. One is appointed as the president, then one is vice president, and another one is as a treasurer. So
who has received a notice?
The
notice means so-called notice.
Yes, so-called notice on page number 44 is in English translation, and the original.
To the village council president.
Yes, only the village council president was given a so-called notice. The other members were not given so-called notice.
Name of the president is?
Lalchandama.
Lalchandama.
Yes.
And the name of the writ petitioner is Lalchandama. So as far as Lalchandama is concerned, you received a notice.
Yes. The other, Siro Thangpuja and Sri Kumthai Rai did not receive so-called notice. out of the 3 read petitioners only, the petitioner number 1 was given show cause notice. Then that show cause notice was replied by the President and the Secretary. Then by impugned notification dated 6/11/2025, the Village Council was suspended.
So that suspension is also to be only for a period of 3 months. Has it been extended?
It,
As per Rule 11,
yes. As
during the period of suspension, Executive Committee shall assume to itself all the powers and functions of the Village Council and appoint not more than 3 persons from amongst prominent villagers. Okay, the yes, the Executive Committee may, on the recommendation of the Commission appointed under Section 10, order suspension of any village council for a period of 3 months at a time,
yes, my lord, actually,
which may be extended for another 3 months.
yes, the handing over of charge to the caretakers is stayed by this honorable court. Then that interim order was still continuing today.
So there is no suspension.
Yes, actually there is no suspension. The charge was not handed over to the caretakers till date. Then by the impugned notification also, it was suspended for 3 months, extendable to 1 month, but it has not been extended nor another order. has
Because
not
of the
been
stay
passed.
order.
Yes, because of the stay order. The petitioners are continuing to take charge of the village council till date.
This order mentions a commission, okay. This, your page 48 order,
Yes,
inquiry commission is mentioned.
yes.
Is there any notification in this regard?
We do not receive any notification in this regard till date.
What about you? Are you aware if any notification is there?
No, my lord.
It is simply stated in that order, an inquiry commission was appointed, but no such appointment order was received by the petitioners.
So we can rely on the part of this covered judgment that notice to the members were not issued. So on that basis only the order can be set aside.
Yes, my lord.
Already heard Mr. Swainshall, learned counsel for the petitioner, and Mr. Learned counsel for respondent.
1 to 3.
1, 2, and 3. Any other respondents?
Yes, Lordship. Other respondents are basically the caretakers appointed by the respondents number 1 to 3.
They have been served or not?
I think there will be AD return.
Huh? No, and they are not served. So how can we dispose? But were they necessary parties?
They are not much necessary
No,
parties.
no, Lordship, they are not necessary parties. In fact, the charge is not handed over to them till
Yes,
today.
no right has accrued, and they are only for caretaker. No, it is not by way of any right that they have been appointed. So you have unnecessarily made them parties. If you delete them, then we can. But for that, you have to file an application because they have not been served. So, if you delete those parties, then we can proceed. But otherwise, as long as the remain parties, unless the service is complete, we cannot. So either you wait for them or you file application for striking them off.
Let, my lord, may I wait for?
Wait.
Yes.
All right. Counsel, it appears from office report that respondents number 4 to 6 have yet to be served. Maybe you can, if you know those people, you can effect dusty service also. It would be open, await service. It would, however, be open for the petitioners to take fresh steps upon the respondents number 4, 5, and 6, including by way of dusty service. This is the matter again on 4 weeks. Interim order passed earlier to continue till the next date of listing.
Oblige, Your Lordship.
17.7.
Oblige.
Hearing list, item number 6.
My lords, I appear as amicus in this matter. My lords, the legal aid counsel along with the PP, my lords, is before the court one, my lords, and I don't believe they'll be done soon. My lords, though we are prepared, we are hoping this matter to be heard. Maybe adjournment.
Who is the
Miss Mary, my lords.
Okay.
Miss Emily. Lords, if 25th of this month is, my lords, convenient. 25th, my lords, if it could be listed.
25th,
Yeah.
okay, on the prayer of learned amicus,
Amicus.
and due to absence of learned additional PP who is on legs in another court, release the matter on 25th.
Obliged.
Item 10.
Yes,
Yes, Lordship, this appeal has been filed, being aggrieved with the judgment and order passed by the learned senior civil judge on 12/5/2023. A declaratory suit was filed, 12 of 2024 was filed to declare the letter
Everything has
dated
been tied up.
2nd of April 2014.
yes,
This was issued by Divisional Commander, Lordship, the Salvation Army to the commanding officer, Dinter Corps, and a suit to declare that the plaintiff are entitled to hold their respective posts and designations in the Salvation Army, Dinter Corps, to which they occupy and hold the office or designations prior to the issuance of this letter dated 2nd April 2014, which was issued by Divisional officer who was inferior to the territorial commander, Lordship. This divisional commander have no authority to issue this letter dated 2nd of April 2014. And this declaratory suit was maintained and counterclaim was filed on 14/7/2017 and issues were framed on 17/8/2017. Out of these 6 issues framed, 3 were ruled in favor of the plaintiff and the other 3 issues were ruled against the plaintiff. The said letter is on page 141, Lordship, page 16 and 141. And the translation is on page 17.
page 17.
Yes, Lordship, the translation is on page 17. This was issued by Divisional Commander who is inferior to the Territorial Commander, Lordship. He has no authority to issue this letter for stoppage of this local officers' commission. He has written as per chapter 1 of section 3, para 5, subclause 5, which is on page 10, Lordship.
Page 10.
Page 10, Lordship. Even if the local officer wanted to resign from his post or make changes by any means, He will submit his commission letter to CO, who will in turn send it to the DC with explanation. If the DC permits, the Commission of Local Officers may be liable for suspension or termination. Any offense in violating promises made by a local officer will lift him from the commission. A person who can give commission or those given authority by THQ will have the power to end the commission. DC means divisional commander and THQ is the territorial headquarters. And in the cross-examination of the sole respondent, he has strictly specified that the divisional commander has no authority. It should be the territorial commander.
So what was the finding of the court?
The finding of the court is on page 595, Lordship. 595. So this is the order, and the decree passed by the court is that the operative part is on page 659, Lordship. Para 40. 659, para 40.
Six.
659, para 40, 40.
Yes.
Para 40, Lordship, that the plaintiffs are directed to hand over the LSC number so-and-so of 2006 along with all the registered documents,
That is
files
the order.
and...
What is the finding?
Yes, Lordship.
That is the order. That-
And a decree was also passed, Lordship.
What is the discussion on this point?
If I may take your Lordship to page 651, para 28.
So the learned trial court upheld your contention that this DC was not authorized to issue the impugned letter. That was accepted by the trial court.
Yes, Lordship.
That is at page 653.
Yes, Lordship.
Letter dated so and so issued by the divisional commander is void. And the issue is decided in favor of the plaintiff, right?
Yes, Lordship.
But because of the fact that you had voluntarily relinquished your post, that is the finding. Therefore, you are not entitled to any relief.
If I may take your Lordship to page 56 and 57, this was the letter which talked of this 12 letter 2 for 2014.
Number 2.
My mistake, Lordship. It's on page 678. Despite of the divisional percentage given, we have been abandoned for 2 years by the headquarter. Because of that only we have issued this.
No,
used
reason
this
may be
letter,
whatever.
Lordship.
Fact remains that you voluntarily relinquished. Is it not?
Nowhere we have mentioned that,
Suppose you
Lordship.
Suppose you resign from service. Suppose I resign from service because of XYZ reason. Fact remains that I have resigned. Is it not? Can I now say you must take me back into service?
We have simply mentioned that from today onwards, that is 29 March 2014, we tell ourselves that Intercore is having no further link by managing ourselves and no other authority above us except God. We also tell the commanding officer who monitored the Intercore on behalf of headquarters to leave the Intercore within a period of 1 week from this day.
So after saying you have no one above you except God, you have come to court. Ah.
So despite of the letter being issued by the divisional commander, he has no authority, only the territorial
That has
commander
already
can
been
have.
said. That has already been held by the court below that it is void.
Yes, Lordship.
But in view of the fact that you yourself have relinquished everything, what relief could have been granted to you?
Yes, Lordship. So, the appellant challenged the legality of the same by filing declaratory suit. We challenge the termination order and prayer amongst other, praying for declaration of this letter as null and void.
Yes, that has been done. Operation successful. Patient died.
Yes, Lordship.
What remains then?
So
And how long back is
surprising-
that? How many
Page-
years have passed? (2014),
Yes, Lordship.
and you are still struggling
Yes,
with
Lordship.
this. You are receiving salary, or what is this? This is a company.
Yes,
Isn't it?
Lordship.
Salary
It is
is registered as a
registered under
company
the
under the
Companies
Companies Act,
Lord.
right?
Yes, Lordship.
So you are in receipt of salary or something?
Yes, Lordship.
Used to be.
Hmm.
Hmm. Yes, what else?
if the order passed by the learned lower court, if this can go for a de novo trial, Lordship, if evidence can be taken again.
No, what has been left out that we should order a de novo trial?
Yes,
That you have to
Lordship,
point
starting
out.
from the counter claim, WS to counter claim, Lordship.
No, why? There must be some reason
Yes,
for
Lordship.
which we order a de novo.
Yes,
And this
Lordship.
is a civil case, not a criminal trial.
And the judgment and order, the learned trial court on page 687 has compared us with United Pentecostal Church Northeast India. This is a wrong ruling, Lordship. It cannot be used in our case, in our suit.
That is on merits. You argue on merits on that. If it has come to a wrong finding, that is what we are asking you. This is the finding of the court that you have voluntarily relinquished. If that finding is not correct,
Yes, sir.
your comparison with XYZ, what difference does it make to the outcome of the case?
And since it involves property, the concerned department, Land and Revenue Department, if they can be implicated as a party for the de novo trial, Lordship.
That was for you to, if it is a necessary party or a proper party, it was for you to make a party. After the suit has been dismissed and you are in appeal, how can we make a party? If you have some substantive suggestions to make, we can accommodate you for some time. But otherwise, I don't see, despite the size of the record, I don't find anything of much substance in there. Yes.
My lord, regarding that submission, so there is no wrong in the order of the trial court. So they are the plaintiff in trial court, then questioning about the necessary party, the Land and Revenue. Why did not they implicate at that moment at the trial court? So the suit they file is regarding only their projection is regarding that their interpretation is termination. But before that, there is a suppression of material fact. On 28 March, before issuance of that letter, 28 March of 2014, they organized, the appellants and their comrades organized a gathering wherein they made a resolution and they declared themselves independence from the Salvation Army, from the respondent.
And expel the commander also.
Yeah. So it is very clear from the evidence itself, from the PWs, from their evidence itself. They say that we parted ways from the Salvation Army. So there is nothing wrong in the order. So even whether that letter, whether they have locus standi to challenge that letter is also, since before issuance of that letter, they have already made themselves separated from the Salvation Army. Then that letter was issued on 2nd of April 2014, that is after their independence. So they are no longer the Salvationists on 28 March of 2014. This letter was issued on 2nd of April 2014. If they are no longer the Salvation Army, then why they are still discontentment about this letter? They are not in a position to challenge that said letter. So regarding that letter also.
So it is like Pakistan issuing a letter to Bangladesh after its independence.
Yes, like that.
Okay.
Lordship, nowhere we have mentioned that we declared ourselves independent. The word independent we have not used anywhere, Lordship.
But you said you have
It's just an
no superior other
interpretation.
than God. Is there not?
And since it involves two
You denied,
LSC,
you repudiated the authority of your senior authorities, superior authorities.
Your Lordship, if I may,
And that is
one
an admitted
evidence-
document.
If I may take you to page number 499 of the paper book, that is their evidence. That is the evidence of PW number 8, plaintiff evidence number 8. 499. Under
Yes.
under page number, under para number 15. Para number 15. If I may read, my lord.
Yes, it is a fact that we have already
We already left the Salvation Army by passing the resolution of Exhibit D1. That is the Declaration of Independence. Exhibit D1 is. And the defendant did not have any option but to relinquish our commission as local officers. It's very clear. So the same has been repeated by their PWs, their witnesses. Their evidence are the same.
All right.
So I think they have no case.
All right. Heard. CAB.
Hello.